And the information that the co-prosecutors and co-investigating judges receive the information from the charged person Kang Kech Yew is not substantiated either. There is no concrete evidence that can prove that the what has been given by Deutsch is reliable, because all the document presented does not show any signature or connection with Mr. Nuon Chea. I did not see any signature or thumbprint of Mr. Nuon Chea on those documents. So it is evident that the claims or my arguments as the defense lawyers for the charged persons are clear enough that my clients be released. This unsubstantiated allegation on my clients does not explain beyond the reasonable doubt on that. So I would like to ask the honorable members of the bench to release my clients either on condition, for example, as what we have done so far with the signature, and this is also the evidence which the bench may take into consideration on the decision. Thank you. I would like to ask Mr. Kope, my colleagues, to please make submission. Yes.
Mr. President, members of the pretrial chamber, Madam Prosecutor, I shall be brief today. I have 11 submissions in reply to what was said yesterday. First of all, the standard of the review of the appeal today. We have stated in our appeal brief that pursuant to well-established civil law appellate practice, this chamber should review the question of provisional detention de novo, without any deference to the legal or factual findings of the OCIJ. And in making the new determination, this chamber has discretion to uphold, quash, or modify the detention order based upon the existing file and any additional information presented by the parties on appeal. Now, the argument that this chamber can only marginally review or review in a limited way the decision of the OCIJ rather than a full review is not a valid argument. My second point, Mr. President, is the question of burden of proof. Rule 63, paragraph 3 does not contain any presumption of provisional detention. Therefore, the burden of proof is and has to be on the moving party, in this case the OCP, to persuade the OCIJ and today you that such detention is necessary. My third point today is the remark of the co-prosecutor whether or not the OCIJ should act as our client's lawyer. Co-prosecutor Mr. Petit submitted that the OCIJ could not be expected to act as our client's lawyer on the day of his arrest and could not substitute its views for those of the charged persons. However, I would like to point out that the OCIJ is statutorily tasked with acting at all times impartially. For instance, the OCIJ should not only seek inculpatory evidence, but also exculpatory evidence. In the absence of counsel, therefore, it did have an obligation to ensure that our client's fundamental rights were protected. And this argument is in no way diminished by the fact that the adversarial hearing is part of the pre-trial phase. And the co-prosecutor's suggestion in attempting to distinguish the Milosevic case that the rights guaranteed to charged persons at the pre-trial phase are somehow less important than those guaranteed at trial is inaccurate. Certain rights, including the right to remain silent and the right to counsel, are identical at all phases of the proceedings and must be equally respected from the moment a suspect is taken into custody until the moment he is convicted or acquitted. Now, as you know, ECC proceedings are inquisitorial rather than adversarial, at least at the investigative phase. And accordingly, if it is to be seen as acting impartially, pursuant to its statutory mandate, it does indeed fall to the OCIJ to ensure the protection of the rights of accused persons who appear before it. My fourth point concerns the interview notes from the DSS. Let me reiterate that the inquisitorial system, as we have here today, does not, in practice, require the advance disclosure of materials, arguments, or authorities to be discussed in submissions. Therefore, there was nothing improper yesterday in referring to the DSS notes of 19 September 2007. Furthermore, we were obliged to refer to those notes because of the explicit reference to the interview by the OCP in its response to our appeal brief. Of course, I am prepared, Mr. President, to make those notes available today. In fact, I have copies with me, but I prefer to do so and to discuss those notes in camera. Now, as argued yesterday, the role of the DSS is statutorily limited, and that office is prohibited from dispensing substantive legal advice. It is, however, permitted to assist charged persons with the selection of counsel. And accordingly, why Mr. Rogers' letter to the OCIJ should have contained anything other than information related to our client's choice of counsel and forthcoming procedures, as suggested by my learned friend, is unclear to the defense. My fifth point is the provisional release at the ICTY. Co-prosecutor Petit submitted that provisional release is rare at the ICTY. In our opinion, this is not quite accurate. The defense knows of at least 24 separate instances of pretrial release at the ICTY, and some 18 occasions where defendants have been released temporarily, subject to conditions similar to those proposed in our brief. Furthermore, any initial reluctance on the part of the ICTY judges in granting provisional release was born of the concern that bail conditions would not be enforced. However, once it was established that such conditions were realistically capable of enforcement, grants of provisional release became more common. And as submitted earlier by us, there is no reason to believe that bail conditions could not be enforced in Cambodia. My sixth point, Mr. President, is the question of the jurisprudence of the European Court of Human Rights. My learned friend submitted yesterday that the cited human rights jurisprudence of the European Court of Human Rights should be considered cautiously and is of little assistance in cases before international criminal tribunals. While at the same time he advocated for the application of the standards enforced at the ICTY. This argument, in our opinion, ignores the fact that the jurisprudence of the ICTY is in large measure based on the case law of the ACHR. Further, the suggestion that international crimes, because of their greater gravity than domestic ones, somehow militates in favor of a more harsh regime of provisional detention is not supported by any of the jurisprudence. Indeed, it is not permissible to base pretrial detention merely on the gravity of the alleged crimes. Again, this argument, taken to its logical conclusion, amounts to an endorsement of de facto provisional detention for international crimes. And in addition to this argument, I would like to stress the fact that the International Convention on Civil and Political Rights, the ICCPR, applies directly in Cambodia. And the European Court protects the same rights as the ICCPR, often in identical language. And they were written at the same time and are intended for the same purpose. Therefore, one should be used to assist the interpretation of the other. I come to my seventh point. Madam Co-Prosecutor Chea Leng noted that with respect to provisional detention, prevention is better than cure. At first blush, this seemingly simple catchphrase has some measure of superficial appeal. However, again, taken to its logical conclusion, it amounts to an endorsement of a regime of de facto provisional detention which of course, as submitted yesterday, is in contravention of established legal principles. My eighth point, the battlefield. Madam Co-Prosecutor Chea Leng noted that our client has described the proceedings of today and further before this tribunal as a battlefield. But this was taken completely out of context, and therefore I would like to read the quotation in full. It's a quotation from the Cambodia Daily from 20 July 2007. It says, Nuon Chea, 82, the highest ranking member of the Khmer Rouge regime still alive, said Thursday that he was ready to face justice and break his long silence about the regime that claimed the lives of more than 1.7 million people. I consider discord a battlefield, and I will not allow you to try me in an easy way, Nuon Chea said by phone from his home in Pailin municipality. At the tribunal, I will show who the enemy was, and I will allow all people to know what was happening during this regime, he said. Now, we will leave it to your honors to determine if Nuon Chea was using the term as a metaphor or making a call to arms as suggested by the OCP. Clearly, the former is the only reasonable interpretation of those words. Then the matter of passport. As noted, the OCP could have verified with the relevant authorities whether our client actually continued to hold a valid passport as reported in 2004. And as we further noted, no passport was found at his home, and he has asserted that he does not have one. In any event, even if he did, the OCIJ could simply order that it be surrendered as is normally done when accused persons are released on bail. My 10th point, that's the remark of Co-Prosecutor Chea Leng. She stated yesterday that 4 witnesses have already indicated that they are afraid. We are unaware of these witnesses, and assuming they exist, it has not been shown that their fear is in any way linked to the release of Nuon Chea. Mr. President, honourable members of the pre-trial chamber, I come to my last point, and that's the remark of my learned friend about the Cambodian Human Rights Action Committee and its amicus curiae brief. Now, it has been suggested yesterday that if the CHRAC would have had the opportunity to review the case file, it might have come to different conclusions. Yet, given the composition of this NGO, comprised as it is, as I said yesterday, of some 23 separate and well-established Cambodian organizations, it is difficult to imagine that any of the information contained on the case file is not in some form or another already part of CHRAC's institutional knowledge. And accordingly, the defense doubts that its conclusions with respect to the grounds of provisional detention would be altered in any way. And specifically, given its comments on the legal culture of Cambodia, the defense suspects that CHRAC's views on the waiver would remain unchanged if given the opportunity to view the video of the adversarial hearing. Thank you very much for your attention.
The bench would like to recess the hearing now, and upon the return from this break, we are going to have an in-camera hearing, so the members of public are not allowed to participate in this hearing. And after the in-camera hearing, we will again open it to public. So the members of public are invited to attend after the in-camera session. So the in-camera session will begin from. Do you have any thing to submit?
Your Honor, is it the more submission about the audio recording or about other?
Further submission concerning the appeal against provisional detention.
Would you like whether we have further comments in response to?
Yes, correct.
Thank you. I think probably it has my role has already been passed because the video recording has already been viewed, and since the floor is now given to me, Your Honor, I would like to address this issue now to respond to the national lawyer, and I will leave the floor to respond to the international co-lawyer by my co-prosecutor. As what stated before lunchtime by the national lawyer, Mr. Sonarun, I think the point that have been raised, we actually have discussed these issues at length already, but the points seem to be repeated. And I would like to add a little bit as stated in Rule 63.
I would like to inform you that you should make a new submission, not the same submission.
I think that as Your Honor, the President raised, I would not like to raise the same thing, but I would like to respond in regard to Rule 63.3 and in point B, which is about the condition of provisional detention, which can include 5 points. This doesn't mean that all the 5 requirements need to be satisfied before the person is provisionally detained, because the term or preposition used is or, which means that any requirement satisfied, then the person, the child person can be detained. I do not need to even add further. Thank you.
Mr. Roberti.
I'm rereading my notes on the comments of this morning from my learned friend. I think most of them I have addressed during my... Sorry, should I start again? No? Okay. I think most of them I have addressed during my response, or we simply reiterate our position as canvassed in our written response and our representations orally before you yesterday and today. So we stand ready to assist any further.
Thank you, Your Honor. I do not really have any further submission to in reply. As the co-prosecutors already addressed, I only pinpoint a small point that Mr. Sonarun addressed this morning in regard to the lawyer of the civil party. He seems to object the statement by Dutch, and if the the testimony by a witness is objected, then I can see that the other testimony of other witnesses or key witnesses will also be objected. So I think this this testimony is very important. It should not be objected. Thank you.
Mr. Hong Kam Soon, please. Thank you. Thank you, Mr. President. Lastly, I do not have any new submission, but I would like to request for the upholding of the provisional detention of the co-investigating judge. But I would like to also make some observations by the defense lawyer who has asked for me to identify my clients. I have already submitted my application to the pretrial chamber, so it is available.
Your Honor, I have another point to add. Among the 5 points raised by the lawyer, one of it, as I observed, is that the main issue is the security concern, as I already addressed, but there is no point to support this argument that when the person is released, then his security would be provided. So when there is any problem happening, for example, in 2003, when there was a riot that led to the burning down of an embassy, which is very important. So security is our primary concern. That's all. Thank you.
The floor is given to Mr. Sonarun, the defense lawyer of the charged person.
Your Honors, again, I would not have any further submission. Mr. Koppe.
I have copies for the bench and of course for the co-prosecutors. I do not wish to give copies to the civil parties. We can deal with the matter in camera again if you like. However, if there are any comments to be made, as I said earlier, we would prefer that to have in camera. Of course we could have done that earlier, but I didn't realize that that topic should be covered as well as the submissions on the video. So my question is to you, should I hand them over to you now and to the co-prosecutor, or should we go back on this, only on this specific issue in camera?
Mr. Koppe, can you explain the court why you don't want to file them, that they are available for the civil parties as well?
Because the information contained in these notes might be seen as privileged information, lawyer-client privilege, and we have no objection whatsoever that you have insight in the full content of this memo, these notes. So the same goes to the office of the co-prosecutor. However, we have no idea if we give copies to the civil parties what will happen to these notes. So in that light, I think also in view of the fact that these proceedings are in principle in camera, for instance, we have also seen the video of the hearing in camera, and this is a specific issue in respect of which we request to go back to the main way in which this proceeding should be conducted, namely in camera. So, what I'm saying is that, as I understand the rules correctly, provisional detention issues should be dealt in camera, unless there are specific reasons to do otherwise. And we have not objected to these proceedings being held in public. Only this specific aspect we would like to go back in camera and present you these notes only to you, only to the bench, to the pretrial chamber, and only to the co-prosecutors.
Are you of the opinion then that the fact that a hearing is in camera means that handed down evidence or written material has a different position than handed over during a hearing in public? Because I cannot find any rule related to that. And on the other hand, I want to observe that the civil parties are a party. And considering to the rules, the parties have, and the lawyers of the parties have access to the case file. Can you comment on that?
Yes, in my opinion, everything that is being said, presented or given in camera should stay in camera. That would be the main position. That would be the rule, so to speak. So if I were to give you these notes, this memorandum in camera, then per definition it should stay in camera. You have also noted that we have objected to the presence of the civil parties on general terms for the reasons set out earlier. That is an additional reason why we believe that they should not receive copies of these notes, which, and then I'm touching another important issue, might contain privileged information, or might be perceived as privileged information. So there are several reasons why I think it is appropriate and diligent to conduct the presenting of these notes in such a way.
You are, I presume, producing these notes as evidence of the authenticity of what you said earlier. You made reference to a number of comments, and these are referred to in these notes. Would it not be possible and cause less embarrassment for everyone if you were to black out everything other than those comments to which you have referred, and then make the document available to the civil parties in the interim, because you have already articulated the sentences to which you referred, and you wish us to take note of. So nothing can be lost if you black out the rest of the document, I would have thought.
That sounds very reasonable. However, there needs to be some work done before we can actually present those documents then.
I think there is no problem with that, and you can file it with our graphia, and it can then be made available to the civil parties because they know what you said already.
Considering this, I think it's a very sensible solution. However, I would like to say that the co-prosecutors may have, after the filing, some additional comments to make, obviously, and dearly wish we would have been in a position to make those comments today, should that material have been, in our opinion, properly filed, taken into consideration the nature of this court. Thank you.
So after the defense lawyer of the charged person has filed that document to the co-prosecutor as well as the defense lawyer of the civil parties, then the prosecutors and the defense lawyer of civil party has the right to submit the response to that comment in writing. Next, the pre-trial chambers would like to inform the parties that as for the supplementary submission, I would like to inform the parties that we will notify the date for such a submission on a later date. The charged person, Mr. Nuon Chea. Do you have your last words or request to the court?
Your Honors, the President of the Pre-Trial Chamber of the Extraordinary Chambers in the Court of Cambodia, my fellow citizens, 1. Today, Cambodia is at peace, and the solidarity and national reconciliation and development of the country has been improving gradually, but the difficulty remains in the country, especially the difficulty that has been influenced by the foreign countries that hinder the growth of Cambodia. The triangle strategy and the win-win policy of the royal government of Cambodia with the leadership of Samdech Akek Mahatecho Samdech Hun Sen, with this leadership, he has overcome all these problems, obstacles, and leads the country to peace and safety. As with this observation of the brief situation, I personally, with other fellow Cambodian citizens, hope in advance that the pre-trial chamber of the extraordinary chambers in the court of Cambodia will use their conscience and its wisdom, clean state of mind to rule on the appeal against this provisional detention order. With my best regard, thank you.
The pre-trial chamber would like to inform the members of publics that the decision of the pre-trial chamber will be in two parts. One is the decision on the participation of the civil parties, and the second on the decision on the appeal against provisional detention of the co-investigating judges. So there will be two decisions finally. The first decision will be on the participation of the civil party, which will be pronounced first. Then we will issue the second decision concerning the concerning the appeal against the provisional detention. And as for the date of the pronouncement of the decision will be made 2 days in advance. The security officer, please take the charged person back to the detention facility. I pronounce the conclusion of the hearing.